Oh, Les, thank you. And thank you for invitation. When I received it from you in late January, we did not think we would be in a significantly changed world and a different Europe, but some things stay the same. And so let's turn to them. And that is the mess that we have made of the digital market and the digital world. I'm going to share my screen. So maybe we'll start off this discussion with my view of what is the great unaddressed issue and resource in competition in the digital market. And after that, then I want to briefly talk about the DMA. Now, if people want to talk about the recent consent decision, we can do that, of course. If people want to go into other aspects of ad tech, I'm happy to do that. But first, I'll start off as I've described. So I work for the Irish Council for Civil Liberties. Before I did, I worked for a publisher, I worked for an ad tech company, and then I worked for a web browser. So I've been on different sides of this discussion. And before that, I worked in the policy world as well. Now, over a decade ago, I wrote a book about the history of the internet, and it was a utopian book. And my view has changed quite a lot. We have several big problems. One of them is privacy. We know we have a broken digital market. That's obvious. We also know that we have a broken information system. And we're starting to feel, and will feel more in the future, algorithmic harms of discrimination and the amplification of polarizing trash. So let's take a look upon these four grim horsemen of online dystopia. I want to focus on competition here. And I think that doing so actually is a way to solve the other issues too. And my approach to competition might be a little bit unusual. I'll explain that in a moment. First, let's think about what the European enforcer has regarded as a win. These are the wins. These are the press announcement ready wins. Major fines in the $1 billion figure or €1 billion figure, supposedly very big. But it is clear when you compare these multi-annual fines to a single year's revenue from Google, which was the target of all of these fines, that these things are totally irrelevant and immaterial. There is something missing. They don't get it. We haven't got it. There is something missing. And sometimes when you've got a complicated issue that is hard to understand, as the digital market appears to be, sometimes it's important to take what looks like complexity and dig into it until you find what is simple, and then you can understand it. You need the small, granular, let's say atomic level thing. And once you understand that, you can build back up from those initial first principles. So we're going to go on a tangent to 1665, because I want to give you an idea of what I'm describing here. This book you're seeing, this beautiful book, is called Micrographia, and it was written by Robert Hooke, one of the founding figures of the scientific Enlightenment. Now, in Micrographia, what Hooke did is he took these microscopes, which he used to create himself. He would grind the lenses with his own hands. And he started to sketch things that humans had never seen. Even though we had dwelt in the same spaces as fleas and flies for, millions of years. Well, actually, more like between 1/4 and 1/3 of a million years. Even though that was the case, no human had ever seen the eyes of a fly. And it took Robert Hooke in Micrographia to show that to us back in 1665. And in that same book, Hooke also shows us for the first time what he calls a small box or bladder of air, a cavern, a bubble, a cell, or a honeycomb. This is the cell. It's the first time humans ever see a cell. This is Robert Hooke's picture of a cell of a piece of cork. Now, with Hooke's cell, you get the first building block for a new scientific understanding. And without the cell, you don't get modern biology as we know it. So that's what I want to do for us in this conversation. I want to find the atomic unit of the digital market. We're looking for the quark, the element, the atom, the cell. And actually, we're looking for the cell or the atom of the use of data. Now, if you ask an engineer or a computer scientist what that unit is, they will go back to information theory. They'll think about Claude Shannon and they'll say it's the byte or the bit. Well, they're wrong. It's not the byte or the bit. That's merely the unit of account of information. What we want is the unit of account of the use of information inside a market participant. And that unit of account comes from data protection law, and it's called the data processing purpose. It is not normally thought of in competition terms, but I would suggest to you that that is exactly what we should start doing. So let's think about this processing purpose thing and where it comes from. The idea comes from purpose limitation. And this has a long history of about half a century. Back in the early 70s, this individual, Caspar Weinberger, who was Secretary of Health, Education, and Welfare in the United States, received a report that his predecessor had commissioned. And he received the report in July 1973. At that point, the administration and thinkers who informed it were starting to wonder what unintended consequences will come from the emergence of records on magnetic tape that can be kept at great scale, but retrieved very, very quickly. The combination of those records in health, but also with social security numbers and credit ratings. And they were starting to grapple, and they did grapple actually in great depth with all of the issues almost that we still grapple with today. So in July 1973, Caspar Weinberger receives this report, which describes the FIPS, the Fair Information Processing Principles. And you will see this incredibly simple idea. It's a common sense idea that if information about you is collected for one reason, or purpose, as they say here, it ought not be used for some other reason, unless there is some very, very good justification for doing so. Now, that appears in very similar terms in the European Data Protection Directive and is alive and well in the GDPR. Here it is in Article 5, Paragraph 1, Point B. You cannot take information that you've collected for one thing and then use it for something else. You cannot have an internal data free-for-all. Now, let's keep this frame of reference. Let's imagine we are Robert Hooke and we're starting to explore the cell. Let's keep this frame of reference and now look at what a processing purpose looks like through one of Robert Hooke's microscopes. Here is some personal data in all its not particularly interesting glory, a bunch of zeros and ones in this case. This, however, must be ring-fenced with barbed wire with an electrical current running through it on its own for its particular purpose, the purpose for which it was collected. The question then is, what fits within that cell or purpose? How big is it? Well, the scope is determined according to European Court of Justice case law by reasonable foreseeability. So you could imagine that you could have different sized processing purposes depending on what the person from whom the data were collected might have considered reasonable. Now, you can start to think perhaps of a periodic table of elements of what processing purpose looked like. That's a complicated project for someone. I'm not sure it would hold up, but it's maybe not a bad frame of reference. Now, let's take out Robert Hooke's microscope from 1665 and look at any modern organization today. And as we get the organization into focus and zoom in, this is what we should see. We should see separate cells, separate processing purposes, And even if it's the same personal data in each, they are kept separate and distinct. But of course, this is a utopia. This does not happen in almost any organization. I have been a data protection officer in an organization that was reasonably large, and doing this is quite tricky, but it must be done, and yet it is not. Instead, this is what happens. Let's imagine that Oles and Johnny set up a new company, and we are going to deliver flowers to people who buy flowers from us on our website. Oles and Johnny will collect people's credit card details, and we'll collect the home address, not just of the credit card owner, but the person who will receive the flowers. And that's only really what we can use those data for. But we probably, if we're thinking dynamically, we will have many other processing purposes that we would like to use those information for. It could be to show ads to those people. It could be to sell them something completely different in a different context. Who knows? In any case, if we are thinking, as many entrepreneurs will, if we're thinking creatively, we will find other ways to use those data. And the more ways we find to use those data, the more dynamic our company will appear to be. You could think of this as a big bang. It is what has made Google, Facebook, Amazon, at least one of the things that have made those companies so incredibly successful, taking data gathered for one reason and using it for other reasons. But this would also make our business incredibly vulnerable to any enforcement of the purpose limitation principle. In the chart here, I say this is like a universe heat death, which a physics person might rightly query, because this isn't a heat death. This would be as though the Big Bang were just instantly reversed and undone. The problem for Google, for Facebook, for Amazon, and for probably all companies is that they have many purposes, but they have very, very few lawful data. Now, let's think about this a slightly different way. Now, hopefully you are thinking the way I want you to think of the processing purpose as the unit of account of the use of data inside organizations and companies. An incredibly useful way of accounting if you're thinking in competition terms. Now let's start to think about markets. It is clear, I've been using this term for a while, that there is a kind of a cascading monopoly happening. And let me explain what I mean there. Oles and Johnny, in an example I often use, let's imagine that Oles and Johnny set up a company that delivers pizza all across Europe by drone. And on the merits, because Europeans love cold pizza delivered from the sky, on the merits, we end up having 200 million customers. And of course, we have their credit card details. We know when they eat pizza. We know if they eat pizza together. And we know where they live and maybe where their friends live. We take those data after a few years and we open up a second business in another market. The second business could, for example, be ride hailing, an app for calling taxis. And we would take all of our data from market one, the pizza delivery by drone company, and we would drop that data. You could say we would offensively leverage that data into market two. And this would probably be very successful, and it would be very bad news for any incumbents in that market. And because that would work so well, Oles and Johnny would continue, and we would cascade our monopoly from market to market to market. You could think of this, if you're thinking about barriers to entry and the Microsoft case, you could think of this as a moat, just dropping a moat on top of the existing market participants and walking over that moat into the next market in a cascade. Now, in the Facebook case from the Bunds Cartel Amt, what Andreas Munt's team is saying to Facebook is, thou shalt not take data from Facebook and WhatsApp and Instagram and presumably also Oculus and cross-use them. And of course, there's a problem with what Facebook was proposing to do. But what Munt's team has not, I think, yet considered, maybe they have, but I'm not aware of it, is that the issue is not only about the cross-use of data between subsidiaries in this conglomerate. The issue is also about the cross-use of data between processing purposes inside each subsidiary. So actually, Facebook in that example looks like this. Very vulnerable. Now, as a user, as a person, an American would say as a consumer, as a human, this is how you experience what I'm describing. When you buy a new Android phone, Google nudges you quite hard to set up a new account. And this is what you see, having scrolled through a whole lot of stuff. Now, the last thing you want to do with your new Android phone is delay things. So of course, you'll click that big blue button at the bottom. But let's imagine you're a masochist and you decide to click this euphemistically termed link called More Options. Let's see what that then says. Clicking More Options, which is quite a euphemism, exposes the following text. And I want to highlight this text to you because it is seismically important. You'll see the title Web and App Activity, which itself seems a bit euphemistic too. 3 sentences here. The first says, we, Google, will take everything that we can collect about you from any Google thing that you use directly. The second sentence says, we will take anything that we can collect about you from any other business that you interact with, where we are present in any way. Now, remember, Google provides an awful lot of infrastructure for the rest of the internet. Even, and you're seeing cases and decisions about Google Analytics at the moment, but think of something like Google Fonts, which has been a subject too. Google is everywhere. And in this sentence, it is saying, we will collect everything from everywhere. And the final sentence, which I'll highlight a bit faster, my apologies. The final sentence says, we will take all of these information and combine them to benefit us on our service, and maybe you as a consumer of our service too. But we'll take it all and mix it. And to make sure this is completely unlawful under data protection law, Google has pre-ticked it by default and then hidden it under something called More Options. Now, the upshot of this is that your shiny new Android phone ends up being the gateway to an internal data free-for-all. That's what Google looks like, except it's not a very detailed diagram. There should be about 90 of these little silos and data being passed between each platter of each silo, being a processing purpose, data being passed between each. And probably we're talking about thousands upon thousands of processing purposes, almost none of which will have a lawful basis. Now, let's think about the market. Let's imagine that I am a person who is using Google Maps in Market 1. I'm using the mapping app. And I am visiting a medical clinic for a particular medical condition that I might have. Or I'm visiting a particular venue, a nightclub, for my particular sexual fetish or orientation. In Market 2, where, sorry, Market 4 in my diagram, where Google is providing the advertising sales on behalf of a publisher. Let's imagine that I visit the Irish Times or the Irish Independent in my market, and I'm reading about some particular political thing, and then I'm reading about my health condition and so on. And then I'm reading about expensive cars and whatever else I'm reading about. All of this, of course, is available to Google because it's providing the ad system to this website, which it does not own. But Google also can bring to bear the information that it obtained about me from Market 1. It knows about my health condition and my sexual orientation. So it can probably have a very good chance at outcompeting the publisher's own ability to pick what ads to show me as well. By the time we get to Market 5, where Google is showing ads at a much higher margin for itself on its own properties, such as YouTube, Google, of course, can use everything it's learned about me and my sexuality and health in Market 1 and my political interests, what car I'd like to buy and so on from Market 4. And now add in 90 other parts of Google. So this is very, very powerful. But back to that idea of purpose limitation. If there were enforcement of purpose limitation, very few, if any, of these things would be lawful. In fact, in some cases, none of these things in particular markets might be lawful because I would have no interest in them happening. And it would be very difficult, perhaps impossible, to get a legal basis for them. So what I'm describing here is a use of the purpose limitation principle in data protection law to achieve essentially a functional separation. Now, maybe to bed this image in your mind, think of that film, 2001: A Space Odyssey, where the homicidal computer HAL 9000 kills all but one astronaut. And the surviving astronaut in this film, Stanley Kubrick's classic film, A Space Odyssey, the surviving astronaut climbs into essentially the brain of the homicidal computer and starts pulling out brain chips. And the homicidal computer is singing Daisy, Daisy, the song, and slowly losing its mind, and the song goes out of kilter. This is what the individual consumer could be doing to Google, to Facebook, to Amazon. They could decide which brain chips to push in and which brain chips to pull out. That is what data protection law can do. Now, I'm going to show you a spreadsheet, and this is my analysis from a few years back of Google's processing purposes based on a large number of documents that it had provided in very different contexts. Some are provided to end users, some are provided to software developers, some to business partners, some in testimony. I'm scrolling through hundreds upon hundreds of processing purposes. And on the right-hand side, you'll see red, because I could not figure out what the lawful basis was for almost any of them. So it seems to me that purpose limitation, that I could have kept scrolling. It seems to me that purpose limitation is the unused big tech kryptonite. And it also seems to me that using the processing purpose as the unit of account for data inside organizations is also very important when considering acquisitions and mergers. Today, DG Comp, for example, takes the following approach. They listen to both parties, the target and the acquiring company, and what they intend to do when they are merged. They do not, however, take a spreadsheet of all of the things that both companies currently do with the data they have and imagine what might happen when those two spreadsheets have children. And that, I think, is what is required to have a data forensics of the acquiring company and the target, and think about what can happen when those processing purposes marry. Now, I want to get back into the wider question of ad tech briefly before getting back into the what's happening inside the walled gardens. Briefly, in case anyone wants to discuss it in questioning, we can, but briefly, there are two things happening in the online advertising market. First, there is an external data free-for-all, where hundreds or thousands of companies throw data about each of us back and forth to each other hundreds of billions of times a day. We are taking aim at that, and I think we're probably about to, we'll see success soon, I think, in fixing it and ending it. But there is also an internal data free-for-all that I've just described to you. Now, the external data free-for-all looks something like this. Your device tells a large number of companies that you are currently on the Financial Times or the Guardian. I want you to step into a publisher's mind and read Google's own terms and conditions. If you go and read Google's privacy and terms, this is the text. This is maximum zoom using Google Chrome. You can make the text very big. Now, I'm going to gray out some of this text. It's one long sentence, and I'm going to remove some words that I think hide the real meaning of this sentence. What I'm suggesting to you is that in the external data free-for-all, where each website and app allows its unique audience to be thrown to the wolves so that other companies, such as Google, can find out who their audience are. This is generally to the detriment of those publishers. And so we shouldn't be surprised when we see that the proportion of Google's profit that is earned from its own properties, as opposed to other companies' properties, has shifted radically over time. Jason Kent of the publisher trade body Digital Content Next has gone back through Google's reports to the Securities and Exchange Commission. It's 10Ks every quarter. And it has found the percentage change. And you can see that it goes from a 50-50 or nearly 50-50 split to now 85% of Google's advertising revenue being earned at much higher margins on its own properties. And probably a lot of this is that publishers have allowed, by not protecting their audiences, they have allowed their users' data to leak into Google and elsewhere, where those other companies can exploit it to their own ends and disadvantage the publisher. So we've got two things happening. We've got the external data free-for-all, which I have not described in this presentation, but I can go into it for another half hour if anyone really wants me to. And then we've got the big tech internal data free-for-all that I have described in this presentation. Now let's talk about what might happen next. First, here's what we've got so far. Big tech companies are very dynamic. They operate an internal data free-for-all, cross-using data for different ends. This allows them to create a cascading monopoly, a rolling monopoly across many markets, or a duopoly. Now we're starting, through our efforts and through others, we're starting to see enforcement against the external data free-for-all. Enforcement of the GDPR, but we're also seeing some tech platforms impose new privacy requirements as well, such as they can be relied upon or trusted, and the jury is out there. Now, we're also not seeing enforcement against infringement of purpose limitation. So it is possible that a big tech company might envelop the entire market. It might become the omni company to which every publisher must go to provide its advertising space, and every advertiser must go to buy ads. And instead of data passing between thousands of companies, it all happens internally inside of Google or Facebook or Amazon. That's what could happen if we see enforcement against the external data free-for-all, in other words, Article 5.1f, the security principle of the GDPR, and if we don't see enforcement of purpose limitation, which is Article 5.1b of the GDPR. But I and others, I think, are pushing for both. We're pushing for enforcement of the purpose limitation principle and the security principle. And it is those two tracks, and we're actually litigating on both as well, because enforcers aren't doing their jobs. It is those two tracks that I think will correct the online advertising market. Now, I wanted to speak just for half an hour before we chat. And so in the remaining 2.5 minutes, I want to talk about the Digital Markets Act, because it is a symptom of a problem in Europe, a wide problem. It's a symptom of a real problem inside the European Commission. And the problem is that Europe doesn't mean business. Every now and again, if you threaten it enough, it'll do something. But, you know, it really doesn't mean business in many, many domains. We have in the GDPR the purpose limitation principle, and in my view, it can fix the digital market. However, this commission is so obsessed with the next generation of European digital law and keeps coming out with new proposals, and it has completely failed to oversee the enforcement of the last generation of European digital law. So we have perfectly good law in the GDPR that can solve the problem that the DMA seeks to address. But this commission has, in fact, rather than done nothing, when it has been challenged on this point, it is producing justifications that are very, very hard to credit. It has a deadline now before the European Ombudsman, after a complaint from us, of the 15th of May to justify why it thinks Ireland, for example, has actually applied the GDPR properly, when it is abundantly clear that it has not. And that is what has allowed Google and Facebook and others to behave as they currently do. So problem one with the DMA is that the GDPR has not been enforced. And so why does this commission expect that the next commission will treat its agenda any better than it treated the last commission's agenda? But there's a second problem in the DMA. There's a very sensible idea here in Article 5.1a that gatekeepers should not be allowed to combine data within their conglomerates. Now, this, of course, is redundant because it's already the case under the GDPR. But this is fine. It's hard to argue against this text, except at the end of this sentence, where they use the language of a singular choice, rather than requiring a lawful basis for each processing purpose, which, if enforced, is going to be very, very challenging for a gatekeeper. Instead, they create a bit of ambiguity. Elsewhere in the text, they say, this text does not reduce the standard of the GDPR. But here they say, with a single choice, see that specific choice, with a single opt-in, you can have your internal data free for all. That is exactly how these companies will interpret this. And this will cost people like me years of litigation to clear up, if indeed it can be cleared up. Now, right now, the Council, the Commission, and the Parliament are in trilogue. And I have been urging them all to fix this problem. And one way to fix it is with a very simple technical amendment. Simply add the following text: choice for each processing purpose. It's a very, very simple idea. And the benefit of doing this in Article 5, paragraph 1a in the DMA is that it then makes explicit that purpose limitation is a tool that DG Comp can use under Article 10 and under Article 11 of the DMA as well. And now, instead of waiting for the Irish Data Protection Commission to someday do its job, the Commission could finally get a crack at it, and we'll see if it's any better. It very well may not be, of course. So let me conclude. First, purpose limitation is unused competition kryptonite. It needs to be used. And second, there is a very important flaw in the DMA that could undo that first point. And on that, I will stop my monologue, and maybe we can have some back and forth on this.